welcome back to the Constitutional Clarion. One of the great joys of doing archival research is finding things that you weren't looking for. It's like a great treasure hunt where you can turn up all sorts of gems, but unlike Indiana Jones, there are no snakes, just paper cuts and dust. Recently, I came across a fascinating letter from Sir Samuel Griffith, the then Chief Justice of the High Court, to the Governor-General, Sir Ronald Munro Ferguson, in 1916, explaining the intended discretion of the Governor-General under the Constitution. Why is this so interesting? Well, first, it's interesting because of the people involved. Samuel Griffith is important because he was a key framer of the Commonwealth Constitution. He prepared the first official draft of it in 1891, which was then negotiated and amended on the Queensland Government steamship, the Lucinda, before being debated at the 1891 Constitutional Convention. On this, see my previous video about the Easter drafting weekend on the Lucinda. While the Constitution was later altered, including by the Constitutional Convention in 1897 to 98, much of the wording and vision remains that of Griffith. Griffith also had the relevant experience. He had not only been Premier of Queensland, but he had also been Lieutenant Governor of Queensland from 1899 to 1903, administering the colony on a number of occasions, including from September 1899 to April 1900, and from June 1901 to March 1902, in the interval between the departure of Lord Lamington and the arrival of Sir Herbert Chermside as Governor. Here's a picture of him in his vice-regal uniform with his lovely plumed hat. So, Griffith had actual experience of the power dynamics between the head of government and the vice-regal officer from both sides of the table. He knew what happened behind the closed doors and therefore had a much better understanding of vice-regal office than outside observers. Griffith, as Chief Justice of the High Court of Australia, had also been a direct advisor to Governors-General of Australia on constitutional and legal matters, so he was fully aware of all the difficulties that had arisen. By 1916, when Sir Samuel sent his memorandum to the Governor-General, Sir Ronald Munro Ferguson, he had long considered the role of the Governor-General, both as intended under the Constitution and as it had developed over the early years of Federation. That role was an awkward one. A former Canadian Governor-General had explained that the role of Governor-General was like a man riding two horses in a circus. This was because on the one hand, or indeed on the one galloping horse, the Governor-General represented the King and imperial interests in Australia and acted on the instructions of the British government about such matters. On the other hand, or bucking steed, he was subject to the constitutional principle of responsible government, under which he acted upon the advice of his local responsible ministers. Between those two horses, we have the rider, who was also given independent discretion in relation to some matters, but it was unclear which matters and on what basis that independent discretion could be exercised. The Commonwealth Constitution was not particularly helpful on that point. Section 2 described the Governor-General as the representative of the monarch, and Section 61 vested the executive power of the Commonwealth in the monarch while making it exercisable by the Governor-General as the monarch's representative. The Governor-General was also made the Commander-in-Chief of the naval and military forces of the Commonwealth and given the power to appoint and dismiss ministers, summon and dissolve Parliament, and give or reserve assent to bills. The only provision that expressly mentions discretion is Section 58 of the Constitution, which says that when a proposed law is passed by both Houses of Parliament and presented to the Governor-General for royal assent, he shall declare, according to his discretion, but subject to this constitution, that he assents in the Queen's name, or that he withholds assent, or that he reserves the law for the Queen's pleasure. But even that is not clear, because this discretion is made subject to this constitution. Does that mean it's subject to the principle of responsible government, or is it subject to the provisions in the Constitution which deal with the powers of the two houses to pass bills? What if both houses pass a bill and ministers then advise that assent be refused? Is the Governor-General's role a legislative one as part of the Parliament to give assent to the bill on the basis that it's been passed by both houses? Or is it an executive role to act as advised by ministers? Or is it one that involves individual discretion? To make things even more complex, because the system of government in Australia was different from that in the United Kingdom, with there being an entrenched written federal constitution in Australia, the Governor-General's role was always going to be different from that of the monarch in the United Kingdom. Hence, the writings and the assumptions of the British authorities on constitutional matters were not necessarily applicable to Australia. In Britain, the word unconstitutional means that something is not in accordance with convention, or doing it is just not good form. It's not cricket. But it is still lawful to do. Whereas in Australia, if something is unconstitutional, it breaches the entrenched constitution and is unlawful. It was this difference that provoked the letter from Sir Samuel Griffith to the Governor-General on the 4th of September 1916. The Governor-General had lent Griffith a copy of this book, Imperial Unity and the Dominions, by the British author A.B. Keith. Griffith objected to some of Keith's observations about the Governor-General and his discretion, causing Griffith to write a memorandum to the Governor-General on the subject. I'm going to read almost the whole of that memorandum here because I think it's quite useful to hear Griffith's view directly in his own words, even though it's rather long. So I'll keep a picture of Griffith here while I read the memorandum so it's clear that they are still his words. Okay, this is what he said. It seems to me that Mr. Keith does not sufficiently appreciate the reality and importance of the powers which are vested in the sovereign and in the self-governing possessions in his representatives under the system commonly called responsible government. The sovereign is, under that system, as much an integral part of the government as are ministers and parliaments. It is seldom that occasion arises for making use of those powers, and such use demands the exercise of the wisest discretion, but the powers are no less real. In the case of the dissolution of Parliament, the power of the sovereign is the same as it always was. But in the United Kingdom, by the effect of long usage, a conventional limitation has come to be accepted, a departure from which would be called unconstitutional. That term does not in strictness mean more than unusual. But as a dissolution could not be carried into effect without the assistance of executive officers, such a dissolution would involve either a prior dismissal of the existing ministers or their assent, that is, their advice. In Australia, and I think in all the other dominions, a wider scope is in practice given to the exercise of the discretion, although opinion has not always been consistent. I have known of a case where upon a defeated minister asking for a dissolution, the governor asked him what he would say if the position were transposed and the governor were the person asking for a dissolution. The minister's answer was, "I would say that I would see you damned first." This is an instance, not the only one within my recollection, of a request for dissolution being made for merely party purposes so as to be able to say that it had been made and refused and without any true sense of the responsibility of the minister making it. There is, and has been for many years in Australia, a school of political thought which maintains that a governor is in all matters, including the dissolution of Parliament, a mere cipher. A distinguished governor of New South Wales once thus described the mental attitude of a brother governor who accepted that view. "Yes, put me in a dark room and give me a pen and ink and I will sign it." I was myself once vehemently admonished by distinguished Australian ministers for not resigning office when the Governor of Queensland, against my strong opinion, exercised the prerogative of mercy in favour of a person convicted in that colony of murder on the high seas. The view of the rule which prevails in any particular part of the empire depends, in fact, very much upon the practice that has been followed in that part, which ministers of limited knowledge and experience come to regard as embodying the absolute and complete statement of the rule. It is an ordinary case of hasty generalisation. I have made these observations to emphasise the view that the power remains as it always was and is not affected by local or temporary variations in the mode of its exercise. It follows from what I have said that the discretion as to granting or refusing a dissolution is personal and absolute. The power of dissolution does not differ in kind from the power to dismiss ministers. Unless the whole governmental authority is absolutely vested in the ministers for the time being without control, some power of control must exist somewhere. It is a fundamental rule of our system of government that this power is vested in the sovereign, who represents the whole of the people, as distinguished from the party holding office for the time being. It is obvious that in order that the discretion may be wisely and effectually exercised, the person who is called upon to exercise it should be conversant with the relevant facts. On this point, again, the practice has not been uniform. In some colonies and states where the accepted view is that the governor is a mere cipher, he is neither expected to have nor thought entitled to ask for information as to the facts upon which the policy and action of his ministers is based, but is left to pick them up as he can. In others, as that in which my experience, both as Minister and Lieutenant Governor, was gained, he has generally, though not always, been regarded as the friendly counsellor of his ministers and has been as fully in their confidence as they are in his. A local and occasional departure from this view cannot alter the real nature of the constitutional relation between the Governor and ministers. If, in the deliberate opinion of the sovereign or his representative, some action proposed to be taken by his ministers would be so detrimental to the welfare of the empire or state that he ought not to allow it, or some action not proposed to be taken by them would be essential to that welfare, it's not only within his power, but it is his duty to dismiss his ministers, provided, of course, that he can find others who will accept the responsibility of the inaction or action which he conceives to be essential. If he cannot, he must of necessity stay his hand. The fact that the exercise of such a discretion requires the possession of many qualities only emphasises the importance of the office. On the other hand, the fact that occasions for its exercise may only occur at rare intervals does not affect the nature of the power or render it obsolete. On the contrary, its continued existence is essential to freedom. Unless the temporary possession of a majority in the representative House of Parliament is to be held to constitute the possessors of it for the time being as absolute autocrats. What I have said further emphasises the importance for the effective administration of the system of responsible government, of full confidence between the sovereign or his representatives and ministers, and the right of the former to full information as to all relevant facts. I am aware that some governors have not acted upon this view, but have regarded themselves for all practical purposes as merely ornamental ciphers. But this fact does not alter my opinion. Similar considerations apply to the power of veto, the exercise of which may be called for under new circumstances, as for instance, if it should appear to the governor upon address from either House of Parliament that its assent to, or non-insistence upon an amendment to, a bill has been communicated to the other House by accident or mistake. Now, I'm going to stop reading the memorandum there because the last bit of the memorandum concerns honours and it's not really relevant. So what should we make of Sir Samuel Griffith's memorandum? First, circumstances have changed since Griffith wrote that memorandum. For example, vice-regal officers no longer represent the British government and take any instructions from it. So the memorandum should not be regarded as determining the extent of vice-regal discretion today. Second, it's interesting that, as Griffith recognised, there were different views and practices in the early 20th century about whether vice-regal officers had real discretion or were no more than ciphers. That debate continues in some quarters today. Third, some of the views expressed by Griffith continue to ring true today. For example, reserve powers are there to deal with extreme circumstances. So the fact that they have not been exercised for a long period does not mean that a convention has developed that they cannot or should not be exercised. On the contrary, it's evidence of the effectiveness of the reserve powers if there's no need to use them. They are most effective when they deter politicians from taking extreme measures that would warrant the exercise of the reserve powers. Griffith pointed out that while there is vice-regal discretion about dissolutions, an election can only occur if public servants carry it out. This means that the only way a Governor-General can positively require a dissolution is either by dismissing the government and appointing one that's willing to advise that the dissolution be held, or by persuading an existing government to advise a dissolution. Another important point made by Griffith is that a Governor-General can only dismiss ministers if he can find others to form a new government and take responsibility. If that is not the case, the Governor-General effectively cannot act. Finally, Griffith saw the Governor-General as representing the people as a whole rather than the political party interests of a government. He regarded the Governor-General's powers as essential to freedom because they can put a check on the tyranny of a government whose members could otherwise behave as absolute autocrats. I think that's an interesting way to think about the position because so much of the discussion about this since 1975 in Australia has framed the Governor-General as the potential autocrat and the government as representing the people. In reality, either is possible, which is why it's important not to frame our guardrails to deal only with one risk based on one historical experience, but instead to maintain that careful balance between the powers of the Governor-General and the Prime Minister, which prevents either from having autocratic power. Thank you once again for watching the Constitutional Clarion. I hope you found this interesting and thought-provoking. And as always, I look forward to seeing you again next time. Goodbye.